Justice Jackson.
The Chief Justice asked you about a gas station on the side of the highway, which is private property. It's open to the public, and you said that we presume that a person can go in under those circumstances. Is that right?
That's correct, Your Honor.
All right. I guess what I'm positing is that the reason we presume that a person can go in is not because they have a constitutional right to go in under the Second Amendment or anything else. The reason we presume they can go in is because property law implies that a gas station owner who has private gas station and opens it to the public has consented for people to come in. So it really is a function of property law and the extent to which the consent is being implied or, expressed, and the state law governing that, right? I mean, it's not, you don't have a right to go into private property. You're only there because the owner has either implicitly or expressly consented.
You have a constitutional right to carry your firearm onto that specific gas station.
You do. Where is that? I thought the reason why this was all here is because you had an implied license. I thought the historical tradition required you to have a license because you don't have a right to go onto private property, and the tradition was we're going to imply that you have a license under these circumstances.
The basis of this lawsuit is that we're only discussing private property where you have a right to enter onto that's open to the public, and we're saying that once that property is open to the public, we have a right to carry a firearm onto it, unless the government.
Okay, I think I understand. Let me just ask you about the black codes. Justice Gorsuch raised it, and I guess what I'm wondering, your answer to him was they can't be and shouldn't be used, and I guess I'm wondering whether that doesn't signal a problem with the Bruin test, that to the extent that we have a test that relates to historical regulation, but all of the history of regulation is not taken into account, I think there might be something wrong with the test. So can you speak to that?
There's nothing wrong with the Bruin test, Your Honor. Just on a fundamental level, the black codes can't be used because they dealt to discriminate against a small.
No, I understand why you're saying they can't be used, but it's because we've moved away from that history, not because that history didn't exist. And so to the extent that the test today is tying us to historical circumstances, it would seem to me that all of history should be on the table. And if we start taking pieces off, whether it's because we've moved away from it or we don't agree with it anymore, I think there's going to be a problem with respect to the accuracy of our test.
Your Honor, it's not just because we don't agree with it anymore. It's that the 1865 law is not relevantly similar because it dealt with a very small segment of society that was being discriminated against, whereas here, law is a law of general applicability. So the two
people other than the people in this small segment that you're talking about, who were a part of society, but I guess you're saying that for the purpose of this test, we're not going to consider what happened to them.
No, what I'm saying is that the black codes dealt with a very, it wasn't a law of general applicability. It was designed to discriminate against, it was a racist law designed to discriminate against African Americans. Whereas here, the law at issue here is a law that applies to everyone. We can't use a racist discriminatory law to justify a modern day law that applies to the general public, Your Honor.
Thank you.